Ashpreet.
See, number one, whether multiple FIRs can be there or not is something that the court would decide upon. As of now, it's just the status report that's been demanded by the Supreme Court that the states should clarify if they are comfortable and convenient, if they deem it convenient that all the FIRs would be combined. See, number two is that threat to Nupur Sharma or threat to anyone, the state should make sure that the threat is done away with and the person is secured and is given security. There is no doubt about that. But nevertheless, the first thing that is to be taken into consideration is that Nupur Sharma had given a statement which attracted FIRs because it was an offence, Section 295A, Section 504 IPC, and it is all in all likelihood, there could be an addition of sections also that could be done. Number three, the Honorable, Supreme Court has demanded this. It does not mean that all the states would say that, yes, they are comfortable with it. Some states might keep it with themselves. Some states might say
one second. I have a problem with the phrase whether states are comfortable. I don't think it's a question of comfort or not. It's a question of a principle of law. Now, you outlined 3 sections that have been filed against her. All 3 sections are similar in all the FIRs. So it's a principle of law whether, look, the offence was one. There were not multiple offences. There was one offence that she committed, speaking in a particular television channel in a TV debate. For that one offence, on the same charges, you can't have cases filed from Delhi to Karnataka.
Wrong. This is where you are wrong, Zaka. Law is all about interpretation. Just because 295A has been invoked in a particular FIR does not mean there cannot be any other section. Section 504 of the IPC is about provoking the peace in a state. Breaching that peace. And there can be more sections as well. According to the interpretation, police stations do it. An FIR is done by an SHO, not by you or me.
Which is exactly what, Ashpreet, the court is saying, that for the same offence, you cannot have multiple, because if you're going to do that, then, SHOs all over the country are going to file cases for everything that happens outside their jurisdiction. But be that as it may, let me go to Maulana Masood Al-Hasan Kasmi. Maulana Masood Al-Hasan Kasmi, the question that's also being asked is, Nupur Sharma, given the kind of threats that she's facing, and today the court has explicitly named one Salman Chishti, this video which came out a few weeks ago, who explicitly called for physically hurting her for her beheading for the comments that she made. Today the court has acknowledged that these comments are a reason for why it has taken a diametrically opposite position today as opposed to what we heard from the court on the 1st of July. So can we at least acknowledge that people like Salman Chishti are actually fishing in troubled waters and making this even worse than what it already was?
Zaka, let me clarify it first that the people like Salman Chishti and another Chishti from Dargah, Ajmer Dargah, they are also further vitiating the communal atmosphere in our country. But the people, today, Honorable Supreme Court has given some relief to Nupur Sharma and has stopped her from getting arrested. So this is the court's matter. SC is expected to hear the both sides before coming to any conclusion, before coming to any judgment. So this is normal proceeding of the court. We should not celebrate this. We should not divide the country over this issue, that this is the victory for that.
No, nobody is saying it's a victory. Again, Kasmi Saab, it's a principle of law.
Victory.
One second. It's
a
principle. No, one second. Kasmi Saab, hear me out. Hear me out. Please hear me out. It's a principle of law. Number one, that for the same offence, you can't have multiple FIRs from Kashmir to Kanyakumari. Number two, that unless you hear one side or the other, you cannot take coercive action, because then that becomes the power of arrest or the fear of arrest becomes an instrument in the hands of the state. Now, you can very well argue it's being selectively applied. Maybe it's being applied in Nupur's case today, but it's not being applied in other cases. That's a fair argument. But on principle, you cannot say that fear of arrest has to be there and fear of arrest can be used by the state just to harass people.
No, the comments which made by Nupur Sharma are highly condemnable.
Yes.
And the country, nation also awaits her arrestment, because in the similar cases, and similar blasphemous cases, many people have been arrested. They have faced the law, they have gone jail, then they got bail. So, nation also is awaiting that this lady also should face the law, and it should also be a deterrent for
No,
other people.
arrest
who
cannot
are
be a matter of
trying to
routine, Kazmi Saab. That is